Hello. Welcome to this week's Private Funds Update. I'm Sandra from SmartEsq. Although there are no major regulatory update this week, we thought it would be useful to provide you an overview of the AI, data privacy, and cybersecurity legal landscape as it applies to private funds. Let's dive in. First up, the intersection of privacy and artificial intelligence. Over 30 states have now passed AI-related legislation, targeting everything from transparency requirements to deepfakes and automated decision-making. Back in September, the SEC's Arsena Believe made it clear that AI is a top enforcement priority, citing its transformational impact and rapid evolution as reasons the agency needs to stay nimble. Meanwhile, California's Privacy Protection Agency is proposing rules that would give consumers opt-out rights when AI touches employment, credit, or housing decisions. And it's not just domestic. The EU, UK, and Taiwan are all tightening controls on how AI models are trained and how data is governed. For any firm operating globally, compliance is getting exponentially more complex. The bottom line? You can't separate innovation from governance anymore. Regulators want proof that you understand how your models work, what data they use, and who's accountable when something goes wrong. And speaking of things going wrong, on October 20th, AWS suffered a major outage in its US East 1 region. The result? Major legal tech platforms including Clio, NetDocuments, Codex, and MyCase went dark. Now, this might sound like a tech problem, but it's really a governance and business continuity problem. The legal industry has become deeply dependent on cloud infrastructure, and despite the diversity of legal tech vendors, most are built on just 3 platforms: AWS, Azure, and Google. When one of those fails, even firms with hybrid systems can feel the impact. The message is clear: redundancy, regional backups, and disaster recovery aren't optional. They're compliance obligations. So how does this connect to private funds? For law firms and legal ops teams, an outage can disrupt e-discovery, contract management, or live deal work. If a virtual data room goes down mid-transaction, that's not just inconvenient, it's potential liability. For private funds, the stakes are even higher. An AWS-level outage could interrupt valuations, investor communications, or capital calls. And then, there's the data privacy angle when an outage happens. The SEC's amended Regulation SB, adopted in May 2024, brings sweeping new data security and breach notification requirements. Larger entities must comply by December 3, 2025. Smaller entities have until June 3, 2026. The rule requires a written incident response program and mandates that service providers give notification within 72 hours of any incident affecting customer information. In other words, we outsource that is no longer a viable compliance strategy. If your vendor goes down or mishandles data, you're still on the hook. LP and portfolio company data is now subject to increasingly strict usage rules. If you're using AI-driven analytics for deal sourcing or investor reporting, those tools fall under the same data governance framework. The big picture? Privacy, AI accountability, and infrastructure resilience are converging and reshaping what compliance really means. For fund managers, legal professionals, and legal tech builders alike, governance isn't a checkbox anymore. It's your product. That's it for this week. You can learn more about these topics from me on the SmartEsq platform. If you are curious about the services we offer, please visit www.smartsq.ai.